Greetings, school law students. We're going to start each module with a vocabulary word, and the vocabulary word for this is stare decisis, which means let the decision stand. And it means that courts are guided by the legal precedents of cases that came before them, and it helps to ensure that there's consistency in cases across jurisdictions with similar questions. It also tells us that justices don't simply make their decisions out of thin air, that they're building on legal knowledge that's come before to help inform their decision making. Now, once a court has made a decision, then every agency within that jurisdiction to which it applies must comply with the decision. So, for example, if the Connecticut Supreme Court makes a decision about schools, then all schools in Connecticut must comply. However, other states actually do pay attention to what's being decided to help influence their cases. So, once in a while, especially with the United States Supreme Court, they make a brand new decision that goes against precedents. And this is called a landmark case. So as you start to follow the law, be on the lookout for landmark cases. Now, let's look at the sources of law. There are three sources for school law. The first is constitutional. And of course, you know that the Constitution guides all court decisions, and that's especially true with amendments. In many school law cases, questions hinge on amendments, and your text does a really good job of addressing this, so make sure that you read carefully about school law and amendments. Now, one thing to remember is that the U.S. Constitution does not mention education. So you might be asking, how is it the federal government is able to make all these mandates on schools, right, and have them follow it if the U.S. Constitution says nothing about education? And they do this by using a particular part of the Constitution, which is Article 1, Section 8. And it's also called the General Welfare Clause, that says Congress has the ability to collect taxes and money for, among other things, the general welfare of the United States. And of course, that includes education. So the federal government, through the Department of Education, passes mandates, passes them along to schools, and puts tax money with it and says, if you want the tax money, then you must follow the mandate. So you might be thinking, well, why don't schools just say, I'm not going to follow that particular mandate if they don't like it? Well, the problem is, if a school says, we don't like this particular mandate, so we're not going to follow it, the federal government pulls all of the money. So that means free and reduced lunch, IDEA, Title I, Title II, not just a little piece of money, all. And it would be crazy for many schools to think that they could operate without that federal money. So you can see that the federal government has built in a lot of power with these mandates. The second source is statutory law. And statutory law are the laws that your state legislature passes, and also the policies that agencies like the Department of Education or the United States Department of Education pass. So those hold the force of the law, and we have to follow these policies and laws that apply to the schools within our jurisdiction. The third source of law is what I find the most interesting. It's case law. And this is when people have a dispute and they take their case in front of a judge. And when that happens, whatever the decision is, it gives us guidance as to what a judge might likely think is defensible or not defensible. So let's now look at the federal court system. The federal court system has three levels. There are 89 district court states, and that's where most cases enter with a federal question to be answered. From there, there's 13 circuit courts, and each state is represented by those circuit courts. So Connecticut is in the Second Circuit Court of Appeals. After the Court of Appeals is the Supreme Court. So the Supreme Court takes hundreds of cases a year, and they take about 100 cases out of thousands of cases, and they vote on which cases are going to come before them. And usually, every year, there's one or two cases that apply to schools. So, as you know, there are 9 justices on the Supreme Court, and they're appointed by the president. And this is a very powerful position, as you likely know, because it's for life. And with life expectancy getting longer and longer, justices can serve for 50 years or more. So it's a very, very important component of a president's job to select Supreme Court justices when someone goes off the bench. And as you know, the most recent appointments are by Obama and Trump. Obama appointed Sonia Sotomayor and Elena Kagan, and Trump appointed Neil Gorsuch. The Supreme Court was pretty well balanced up to then, but with Trump's most recent appointee, it's shifted far more conservative and to the right. And this is important because the Supreme Court shapes rights for everyone, and so it's important that it does stay balanced. And by the way, the court never hears a hypothetical case, right? They only rule on real cases that come before them. And they rule specifically on the question related to the case. They don't make broad sweeping decisions about a topic, generally. All right, so let's look at some of the groups that make our statutory laws. Of course, at the federal level, you have the U.S. Congress, and then we have policies that are set out by the U.S. Department of Education. And that's kind of mirrored at the state level on the state legislature and the state Department of Education. Most states have a Department of Education that handles the roles related to education and teacher certification and make sure that teachers are prepared adequately. But some states have two different entities, like a professional standards committee, as well as Department of Education, but that's unique. Georgia is an example of one place like that. All right, so down at the local level, the policies at the local level are set by the school board, as you likely know. There's one thing that you should know about the school boards. I think people often don't realize, even though it's a local school board, boards are state agencies. It's not a local town agencies. So there are local people working at local school districts on a school board itself, but the school board itself is considered to be the state agency. And they must represent the views and the laws of the state in which they're operating. And similarly, by the way, teachers and school employees are also employees of the states, not employees of the local town. They may be paid by the local district, but they're seen as employees of the state, which you're going to see is very important in school law. So having said that, think about your school board members because they're employees of the state. And because this is a public business, they have some rules that they have to follow, and they have to hold their meetings publicly. And as a public business meeting, they must be held within the boundaries of the school district. They can't go out and have a clandestine meeting, right, where they don't tell anybody about it. Or maybe it would be against the decision for some people to, they wouldn't be able to attend because they're against that decision, right? So they make it out of town, right? So they can't do that. Their records and their actions have to be public. Their agendas must be posted ahead of time. So they really have to operate in a public manner. There's also a rule that they can't, as I said, they can't hold the clandestine meetings, meaning they cannot have a private meeting. And they also can't have a small group, come together to discuss something like at somebody's home and then just decide what they're going to do and then just kind of have a pretend meeting, right, where they have a discussion but they've already made a decision. That's not allowed. They really have to do public business in the public. Now, as you probably know, they are allowed to go into an executive session, and an executive session is allowed under certain particular circumstances. So, for example, what they may be doing in the states that have unions, they're allowed to go into executive session, right? If they're going to purchase property that they can talk about in executive session, because sometimes if you say it publicly, then the price of the property might go up, they can do that. When it might be in the best interest, when people know that the school district is interested in something else and the price is raised, they could have an executive session. If they have a case pending against a school district employee, and they have to consult with an attorney, right? They can do all of that in a closed session. They can also talk about specific personnel issues, like whether or not somebody's going to be fired. We certainly wouldn't want that to be out in the open. Or even an expulsion case with a student. So there's some private things where privacy is important and the courts do allow them to act in executive session, but they should not be talking about regular board topics without being done, that should be done in a public meeting. So as you can see, the court system, the statutory system, the federal level, federal courts, the federal U.S. Congress, and the Department of Ed is really mirrored at the state level. In the state court system. And you also have your state level legislatures and then your Department of Ed, and then you add your local board members who, remember, are employees of the state, and they make specific guidelines and policies that we must follow in our schools. So that gives you a quick overview of legal basics, and I'll be back with control of public schools soon.